Trump breaking news. Before Labor Day, a federal trial involving Trump is still possible. Former President Trump has claimed that he is immune from criminal prosecution. Last month, the Supreme Court agreed to review this argument and put federal criminal proceedings against Trump relating to January 6 on hold. There was an immediate and raucous chorus of people claiming that the Trump trial would never happen because of this one-page court order, and it wasn't because they are afraid the court would accept Trump's unusual immunity claim. However, many raising concerns are of the opinion that Trump will not be tried before the election, even if the government succeeds in its Supreme Court appeal. But those worries assume that a verdict won't come until around the 4th of July because the court decided to hear oral arguments in April. Plus, that's bad. You should still be able to get a ruling by Memorial Day, even if the oral argument is in April. The Supreme Court's most high-profile issues typically take months to resolve, and the court's opinions in these matters typically arrive around the close of the term in late June, although that isn't always the case. Realizing the significance of swiftly resolving a case, the Supreme Court has, on multiple occasions, issued opinions within weeks, or even days, of oral argument. For instance, in the well-known case of Bush v. Gore, the Supreme Court notably decided on two separate cases stemming from the 2000 election's Florida recount in the approximately 3 weeks that spanned Thanksgiving and Christmas. The Supreme Court heard oral arguments in the case of United States v. Nixon on July 8 and rendered a ruling in the matter about 2 weeks later, on July 24, regarding the release of the Watergate tapes by President Richard Nixon. The Supreme Court heard oral arguments in Dames and Moore v. Reagan on June 24 and issued its decision on July 2, challenging President Jimmy Carter's decision to freeze Iranian assets in response to the hostage situation in Iran. It took the Supreme Court only 4 days following oral argument in the case of New York Times Company v. United States to rule that newspapers could publish passages of the Pentagon Papers. Less than 30 days after hearing oral arguments, the Supreme Court finally handed down its ruling in the Trump ballot eligibility case today. Similar speedy resolutions are possible in the Trump immunity case. Ultimately, the court decided to focus on a single narrow issue: whether and to what extent does a former president have presidential immunity from criminal prosecution for conduct claimed to entail official acts during his stay in office? Additionally, a panel of the D.C. Circuit, which includes judges chosen by both Republican and Democratic presidents, has previously proven that this matter may be decided swiftly and conclusively. In a nearly 60-page unanimous decision, the D.C. Circuit rejected Trump's assertion that past presidents are exempt from criminal prosecution regardless of any wrongdoings committed during their time in office, less than a month after hearing oral argument on the same subject. According to the reasoning of that court, Trump's position conflicts with both the language and the background of the Constitution. Notably, there is no express provision of immunity to the president in the Constitution, despite the fact that several state constitutions of the period contained executive immunities and the federal Constitution contained certain explicit protections for lawmakers. Why? Look no further than history to provide an explanation. The Constitution established the office of the President as a new and powerful executive branch, a radical change from the Articles of Confederation. Although the framers of the Constitution had no intention of establishing a monarchy, they took measures to guarantee that the newly inaugurated president would not be far from being above the laws, as James Wilson phrased it in his address to the ratifying assembly in Pennsylvania.